1976, Alabama led a nationwide charge to reinstate the death penalty. Their mission was accomplished when the Supreme Court upheld a Georgia statute in the case Gregg versus Georgia. This case revived the death penalty, specifically in Georgia, Florida, and Texas, but soon to be followed by other states, because it provided clarity as to who would be subject to capital punishment and gave much of the power to decide to the jury. In today's edition of 600 Seconds, we will be interviewing experts on capital punishment in Alabama, infamous for their 20th century death penalty laws, thanks in part to Brian Tyler Stevenson's Just Mercy, and seek to learn more about the death penalty by analyzing past cases in the post-Gregg versus Georgia era. Our reporters will attempt to uncover the hidden biases found in our court system. They will also talk about how Alabama stands out in this seemingly never-ending debate. Right now, we're going to head over to Mary for her exclusive first-hand interview with
Welcome
John.
to 600 Seconds, John. Tell us a little bit about yourself before we get started.
I'm John Hennifer. I'm a legal historian from the University of Alabama for 13 years. I've seen the death penalty change a lot over my career, some for better, some for worse, but hopefully we can start moving in the right direction.
I'd like to start with one of the biggest drivers of inequality in the capital punishment system, and that is racism. Could you tell us a little bit about the history of racial biases as they relate to the death penalty?
Sure. It all started in old America where African Americans would often be blamed for crimes they didn't commit, and they would be chased by racist mobs and lynched and killed. And this has continued through the 20th century into today's world, where African Americans are more likely to be discriminated against in court, and even on juries, they're often excluded and aren't allowed to participate.
Explain what the plain error law was in Alabama.
The plain error law allowed the Alabama Appellate Court to review any major death sentence cases or capital punishment cases. Unfortunately, it was overturned, and now the Appellate Court is only allowed to review those cases if the defendant's lawyer asks for it. And this has caused a lot of issues because people who have maybe public lawyers or lawyers that are not as expensive, I shall say, often don't get this privilege to challenge this case. And it has made a lot of people vulnerable to death sentences because they can't afford to keep going into the appellate system.
How would the overturning of a law like that impact people who don't have access to pay for good defense attorneys, such as Anthony Boyd, a man who was wrongfully convicted without any DNA evidence?
Yeah, so as I was saying, people who can't afford as good of a lawyer, those lawyers who are often public are more likely to put less effort into their case, and that extends into death penalty cases where those lawyers are unlikely to keep fighting even after a conviction has been made, and they are more likely to just give up. And so since the lower class of people that can't afford good lawyers are more likely to be in that situation, like you mentioned Anthony Boyd, it exacerbates these class divisions where people can't afford good lawyers and they continue to be sentenced to death because of that.
You've really shown that racism and class divisions are a big issue in the Alabama court system. Could you explain how these two issues combined can lead to prosecutorial misconduct in the courts?
Yeah, so one of the most egregious cases of this recently has been the case of Artez Hammonds. And in this case, the prosecutor had a long history of terrible remarks in court, and also a history of striking African American jurors unconstitutionally off court. So this man, District Attorney Douglas Velasca, he was ordered by the court not to make remarks about Artez Hammonds' pleading of the Fifth during his investigation, and in flagrant violation of this order, he did it anyway. So in his reign as the district attorney, he has led to a 16-fold increase in death sentences over 1995 to 2008. So it's very clear to see that even today in Alabama, there are still massive issues. There are still plenty of people in power who are fueling this issue in capital punishment being racially discriminated against African Americans.
Thank you so much for your time. I feel like I've learned a lot from you about the injustices in the Alabama courts, and I hope I can talk to you again soon.
Yep, I hope we see some change.
Thank you, Mary and John. Even today, there continues to be political and social tensions surrounding the institution of the death penalty. Capital punishment is currently legal in 27 of the 50 states. On an international level, just 55 nations and territories allow it, with the United States being one of them. In the United States, there is a short but very important history of botched executions. Though very rare, these horrific instances have fueled anti-death penalty arguments for decades. Meanwhile, those in favor of the death penalty have argued that doing away with some of the country's worst criminals is worth the occasional slip-up. In our next interview, we will go deeper into some of the catalysts behind this political divide, revealing in specifics the two sides of this complex debate, and some of the evidence each side has used to support their claims. We'll now head over to Mary and Livy for more.
Hello, this is Meredith Johnson here with Representative Libby Gummel from the Southern Center for Human Rights. Let me just start by saying thank you so much for joining us today. Tell me a little bit about what your organization seeks to achieve.
It's great to be here today. So I'm Livy and I work with the Southern Center for Human Rights. And over the last couple years, we've been studying racial violence and capital punishment and how racial inequalities have been in the American South over the last several years. I'm glad to be here today to share the context and how the judicial system has changed in Alabama over the last several years.
Great. Okay, let's get started. What was the significance from the John Evans case after the landmark decision from the Gregg v. Georgia case? Why was it such a turning point for Alabama's involvement in capital punishment?
The Supreme Court reinstated the death penalty after Gregg v. Georgia case in 1976. And it was then that Alabama began to resume their executions. The case of John Evans III became the state's first modern execution in 1983, and it was very controversial. This is because his execution was botched, unfortunately, resulting in 3 separate shocks over the course of 10 minutes. This was their first use of the electric chair after the Gregg v. Georgia case.
So, considering the imprecision involving the use of the electric chair behind this case, how does this reflect the unfairness of capital punishment?
It showed how unpredictable and uneven the system can be. If the state can't even carry out an execution humanely or reliably, it raises real questions about whether the entire punishment is being with care or fairness. Their turning point was truly the fact that it showed Alabama's aggression to enforce capital punishment, and many suffered from this, deserving or not.
Has Alabama ever reconsidered the death penalty after this case?
In 2016, Alabama was ordered by the court to reconsider its death penalty sentencing procedure. This was after Bart Johnson was put on death row after committing murder and claimed mentally ill affected his actions. Alabama at this time allowed a judge to override a jury's final decision, even if the jury was unanimous. This is what happened during Johnson's trial.
Was there any evidence to righteously claim that Johnson was mentally ill? If not, would this be considered prosecution? Was there any evidence to righteously claim that Johnson was mentally ill? If not, would this be considered prosecutorial misconduct?
Johnson presented a real expert testimony that claimed he had multiple mental disorders, including identity disorder and personality disorder traits, suggesting that he had a different view of reality. However, the state found no evidence of psychosis and rejected the defense's argument on mental disorders. There was evidence found though, so there is a question of whether the state was biased or not.
If there were physical medical records that proved Johnson's mental illness, it would be unjust to ignore obvious evidence to conclude that his actions weren't technically intentional, correct?
For the courts to have rejected Johnson's attestation claiming mentally ill, they would have needed substantial evidence to counter a medical professional. So this leads to the question, was there evidence or was the court influenced by biases?
Libby, thank you so much for your time today. It seems like the court's work for capital punishment has seen a lot of change in the last few years.
Yes, that is true. It was truly great being here and able to discuss how justice in the South has evolved.
In Brian Tyler Stevenson's previously mentioned novel, Just Mercy, 3 major themes are explored: just punishment, justice, and merciful punishment. When one is charged with capital punishment, it is almost impossible for the judge and the jury to have mercy. As has been revealed from our interviews, many argue that this punishment is just. The crimes committed by these individuals charged with capital punishment are often horrific. Thus, there is clear tension created between just punishment and merciful punishment. Thank you so much for tuning in to today's episode of 600 Seconds. We hope you enjoyed the topic, and we hope to see you next time. Thank you.